Assalamu alaikum and greetings to all students. Today is the fresh lecture, lecture number uh, 13, and this is the continuation of our course. In this course, that is the international criminal law, which we have started journey and regarding the understanding of the international criminal law, its principles, legality, and forums, history, and need of the that international forum, which actually adjudicate, investigate, and try to the crimes which are committed beyond the boundaries of the nationalities, um, identities. So we have discussed in the previous 12 weeks. We have tried to understand the mechanism regarding the international criminal law and the crimes, core crimes of that nature. This is the second part of our lecture. That the second scheme. In this part, we are learning the core crimes, substantial part of the this course. So today, students, today in this today's lecture, I'm going to demonstrate or giving my lecture on the today's topic, that is the crime of aggression. Because I select this topic in the last substantial part, because the certain developments required in order to implement this part of a crime in the ambit of the international criminal law. Because initially, when this crime has been tried in a Nuremberg trial, so there was no any definition of the crime of aggression. So in the name of a crime against peace, that crime was tried. Thereafter, this crime has the discussion on that crime has been evolved, and thereafter this crime mentioned or in the international jurisdiction, crime of aggression, that a crime actually committed during the the war, the atrocities, the military invasions, force war on the any country, and that use the tactics during the war crimes. So that is the actually crime of aggression, and how it and this crime constitute. So here is the we are going to start from the beginning. First of all, we have to understand what is the crime of aggression. Thereafter, historical background. So here is the I'm sharing the screen. Here's the screen of the international criminal law crime of aggression and its history of the crime of aggression. We are going to start before understanding the history. I'm first of all define the aggression. What is the aggression? Is defined as the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of the state of an act of aggression which by its character, gravity, and scale constitute a manifest violation of the Charter of the United Nations. How United first initially the definition of the aggression under General Assembly under the resolution number 3314, and that is the 24 resolution. General Assembly resolution which defined the aggression is the article number 1 of the United General Assembly resolution 3314. Aggression is the use of armed force by a state against the sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations, is set out in this definition. So Article 1 of this definition is very broad and relies heavily on the Article 2 paragraph 4 of the United Nations Charter. Article 3 of the definition provides a list of specific acts which may specify as acts of the aggression. However, this list is not exhaustive, as the United Nations Security Council may determine additional acts of the aggression. Article 5, paragraph 2 differentiates between a war of aggression, which is a crime against international peace, and aggression, which gives rise to international responsibility. Accordingly, not every act of the aggression can be considered a crime against peace. In a differentiating between war of the aggression and acts of aggression, the legislator of this definition clearly indicated that only a war of aggression constitutes crime against the peace due to the intention and the element of the acts of aggression that fall short of war only lead to state responsibility. The various articles within this definition illustrate the compromises made by the states in order for a consensus to be reached. Although the General Assembly definition is considered the most recent and widely accepted uh, definition, but it has been also criticized as being a vague and overly state-centric, in that it makes it difficult to prosecute individuals for acts of the aggression. In addition, further understand the crime of aggression, we have to look into those facts which actually constitute the crime of aggression. So uh, we have to um, uh, look into the evaluation past historical facts of regarding the crime of aggression. What was the reasons this crime actually tried or made the jurisdiction of the ICC and in other international forums. So the what is the history and the historical background of this crime? The aggression comprises the participation by states, leaders, and policymakers in a certain aggressive acts on a state. It is regarded as the crime under customary international law. It does not have a universally agreed definition. The first international trial of aggression under the name of crime against peace was before the Nuremberg International Military Tribunal following the World War II. The United Nations War of Commission discussion, which preceded the draft of the London Charter and set up the Nuremberg IMT, International Military Tribunal, showed that it was by no means a widely held view that there exists a crime of aggression under international law, as it then stood. Article 6, paragraph clause A of the Charter gave the Nuremberg International Military Tribunal jurisdiction over the crime against the peace. Defines as the planning, preparation, initiation, or waging of the war of the aggression, or a war in violation of the international treaties, agreements, or assurances, or participation in a common plan or conspiracy of the accomplishment of any of the foregoing facts and reasons. So the first trial on those crimes, the Nuremberg International Military Tribunal had to deal with the objection of the accused that the charter created a new law and that the tribunal applied law ex post facto. It dismissed this claim by ruling that ever since the 1928 College Brand Pact, aggressive war had been a crime under international criminal law. Thereafter, there are certain other factors which are involved in that historical developments. is the first international trial for the aggression was held after the Second World War, before the International Military Tribunal at the Nuremberg. International aggression was first criminalized under the crime against the peace. In the Article 6, Clause A of the Nuremberg Charter, which states that the crime against the peace, namely planning, preparation, initiation, or waging of a war of aggression or a war in violation of the international treaties, agreements, or assurances, or participation in the common plan or conspiracy for the accomplishment of any foregoings, and Article 5 of the Clause A of the Charter of the Tokyo Tribunal included a comparable definition of the crimes against peace. The same definition, but there are certain changes. The planning, preparation, initiation, or waging of the declared or undeclared war of the aggression. This is the sort of addition, or war in violation of the international law, treaties, agreements, or assurances, or participation in a common plan or conspiracy for the accomplishment of any foregoing. The Tokyo Charter, unlike the Nuremberg Charter, defined crime against peace by referring to a declared or undeclared war of aggression. The United Nations War Crimes Commission concluded that the differences in the definition contained in the two charters were purely verbal and that they did not affect the substance of the law governing the jurisdiction of the Far Eastern Tribunal over crimes against the peace in comparison with the Nuremberg Charter. A similar provision was also included in Article 2, Paragraph 1, Clause A of the Control Council Law number 10, which defined crimes against peace as the which states that initiation of the invasions of other countries and war of aggressions in violation of the international laws and treaties, including but not limited to planning, preparation, initiation, or waging a war of the aggression, or war of violation of the international treaties, agreements, or assurances, or participation in a common plan or conspiracy for accomplishment of any of the foregoing. Although the criminalization of the aggression and the Nuremberg Charter paved the way for equivalent provisions in both the Tokyo and Control Council Law number 10, accomplishment of the Nuremberg Tribunal were not easily obtained. For instance, the accused objected that the Nuremberg Charter created new law, and that the International Military Tribunal applied law as the ex post facto, because at that time there was no law crime of the aggression. So that was the first objection, thereby violating the principle of the nullum crimen sine lege. The accused primarily objected to counts 1 and 2 of the indictment. Count 1 of the indictment charged the definition with the conspiring or having a common plan to commit crimes against the peace, and count 2 charged the defendants with the committing specific crime against peace by planning, preparing, initiating, and waging wars of the aggression against a number of other states. As a result, the principal challenge facing the prosecution was to establish the legitimacy of the crime of aggression. The Nuremberg Tribunal rejected defense claim of the retroactivity, holding that aggressive war had been a crime under international law since the 1928. In the Clark-Barrett Pact, there was a treaty regarding the aggressive wars, crime against peace. So at that time, that crime was not name given as the crime of the aggression, but crime against the peace. So that pact states that in the opinion of the tribunal, the solemn renunciation of the war as an instrument of national policy necessarily involves the proposition that such a war is illegal in international law, and that those who plan the wage such a war with its inevitable and terrible consequences are committing a crime. Solution of the international controversies undertakes as an instrument for national policy certainly includes a war of aggression, and such a war is therefore outlawed by the pact. The Nuremberg Tribunal further declared that initiating a war of aggression was a supreme international crime, differing only from other war crimes in that it contains within itself accumulated evil of the whole. After the Nuremberg judgment, prosecutor at the tribunals established pursuant to Control Council Law Number 10 continued to pursue charges against the defendants for crimes against peace in occupied Germany. 4 out of 12 trials conducted from 1946 to 1949 dealt with the charges of the crime against peace. The tribunals that succeeded the Nuremberg Tribunal considered themselves bound by the jurisprudence of the International Military Tribunal on crimes against the peace and built upon the foundation of the provided by the Nuremberg Charter and judgment. So the foundation of the crime of aggression has been provided by the Nuremberg Charter and its judgment. That was the landmark decision of the Nuremberg Tribunal, which actually convert the crime against peace in the crime of the aggression. Tokyo prosecuted crime against the peace. The prosecutors at Tokyo Tribunal indicted many defendants with 52 or 55 counts in the indictment relating to the crime against peace. Very important, the Tokyo Tribunal rejected the defendants' argument that the aggressive war was an act of the state for which there was no individual responsibility under international law, and that the charter provisions were ex post facto legislation and therefore illegal. The Tokyo Tribunal further supported the opinion of the Nuremberg Tribunal when it concluded that aggressive war was a crime at international law long prior to the date of the declaration of the postedem. It is important to note that the crime of the aggression was not only universally considered form of part of the customary international law prior to its inclusion in the Article 6 Clause A of the Nuremberg Charter. However, once the Nuremberg judgment found Article 6 Clause A to be declaratory of the modern international law, it has provided a precedent which eventually resulted in the crime of aggression become indisputably part of the customary international law. The description of the aggression in the ILC Law Commission draft the Nuremberg Principles copied the description of the aggression found in the Nuremberg Charter, that is the Law Commission ILC's draft principle and code of offense, however, were never adopted by the General Assembly. So only on December 1952, the General Assembly recognized the complexity of defining aggression and decided to establish a special committee consists of the 15 states to draft definition of the aggression or draft statements of the notion of aggression. However, the special committee and 3 subsequent special committee created in 1954, 1957 and 1967 never adopted a definition of the aggression due to in part of the prolonged negotiation made difficult by the tensions of the Cold War in which they were conducted. Approximately 22 years after the establishment of the first special committee, the General Assembly finally adopted a definition of the aggression on December 1974 through the resolution 3314 26. The adoption of the definition has been described as the historic movement. Although the definition was regularly cited throughout the Cold War, it was never relied upon to prosecute a defendant in a criminal trial, and it was never cited by the United Security Council. So it was the short and brief history regarding the crime of the aggression. So after it, Now we are moving towards the definitions. How